start. In general, there's 4 types of intellectual property: trademarks, copyrights, patents, and trade secrets. Copyrights protect original works of authorship, so like the documentary that you're producing, or if you've written a book, the content on your website, things like that will be protected by copyright law. You do have rights when you create something, but if you register it with the Copyright Office, you are entitled to enhanced damages if anyone infringes on your copyright, and there's like formal proof of your ownership and registration. The patent will protect ideas that are unique, non-obvious, and not disclosed. I'm not a patent attorney, but that's a little bit about patent law. Trademarks are where I spend about 60–70% of my time. A trademark, it can be any word, design, or sometimes a smell, color, or sound that is used in connection with a particular good or service. And then trade secrets are also assets of a business. The main thing about a trade secret is that you really do need to take steps to keep it secret. Don't have it out there on your Google Drive for anyone to access. You know, have it in at least a protected folder that's like password protected. You're only sharing with people that need to know about it. So, a little illustration about some things that might come up. This is a vacuum. So this could be incorporating all types of intellectual property. I just made it up this morning. Buy a vacuum today and watch all of your problems get sucked away. So you would have a copyright in the ad, the way it's laid out, you know, the particular colors and that text and the image. Although actually I created this with AI, so there's a big question about whether you can get a copyright in it or not. We'll talk about that later in time. You may get a patent if the method of getting dirt up is unique and you've applied for a patent. And then the trademark would protect the name, and if there was a logo for Sucks vacuums, that would be protected by trademark law. Oh, and I wanted to note also, I did a poll before on the Whova app. I saw that about 2/3 of you already have a trademark, and about 1/3 of you don't have anything yet. Also, feel free to interrupt me at any time. We have a lot to go through, but I really would like to answer any of your questions. So really, anytime, just raise your hand and we'll get to it. So first off, there are 4 secrets or strategies to a strong trademark. You should use a weird word or design. Make sure your mark stands alone. Do a comprehensive search and avoid some common mistakes. So a weird word or design, it's always a balance with marketing people who want to make the product name as descriptive as possible, like grade chair, so that people know what it is. They don't have to spend a lot on marketing to get people to associate the product with the brand name. However, from a trademark perspective, made-up words are actually the strongest trademarks ever. That's why Lululemon and Starbucks are such strong brands. They're totally made-up words that don't exist in the dictionary, and they are the only ones using them. This will give them like a very strong sphere of protection around their brand. So if anyone uses something similar, they'll have a good argument that it's infringing. They also have, of course, huge trademark portfolios that they can call on and back them up if they're writing a cease and desist. One of the other things is to make sure that your mark is not only weird, but also a little bit lonely. Some people want to use words where there's a lot of other people in the industry using it, especially like in the outdoor industry. People will use outside or outdoors or adventure. Those words are great, but you're gonna most likely end up in what we call a crowded field. In a crowded field, you may be able to get a registration. However, it's going to be very difficult to enforce your mark because there are all these other people using similar marks. So just beware if you're thinking about using a word that's sort of descriptive or that a lot of people in your industry are using. that could be an issue. And then this really should be the first secret or strategy, is to do a search before you apply. And when I say search, I'm not just talking about the knockout search on the USPTO website, which is a good start. It lets you know if someone's using the exact same term. The USPTO does have a new version of their search tool, which may return some expanded results, but you really should also be looking through Secretary of State records, internet, social media, Dun & Bradstreet records. This is the most important step because this will let you know if there's anyone lurking out there that could later take action against you. Yes?
So a lot of people do their own trademarks.
Mm-hmm.
This is a part that probably people mostly just do a Google search.
Mm-hmm.
Maybe they look on GoDaddy or something to see if the domain is available. I'd love to hear a story of like how someone thought they did a search and then it bit them in the butt.
Yeah, so some people will do that knockout search on the USPTO website. That's a great question. And I have so many stories. That's how I've been in business for more than 15 years. So many people will do a knockout search, think that they're safe, file their application, maybe the application even achieves registration. And then after they spent all this money on their website or signage or packaging for their product, they get a cease and desist letter and they're like, well, I don't understand. I got the registration with the USPTO. No one stopped me. What's this about? Why didn't they tell me sooner? I can give you an example actually just from earlier this week. I have a client in the UK who has a registration on their fertilizer product there. They were very strapped budget-wise. I encouraged them to do a full search in the US. It is also the most expensive part of the process when an attorney does it, by the way, but it's really, really important. So I hardly ever will represent someone who wants to just file a trademark without doing a comprehensive search yet, because it's also my reputation on the line. Our firm has something like an 86% success rate on applications going through with the USPTO. Anyway, they were very strapped on budget. I don't know how they convinced me that we should just file without doing a search, and it's in multiple classifications. Each classification is either a $250 filing fee or a $350 filing fee, depending on whether you use the T's plus, which is like the canned descriptions of goods and services, or the regular T's. I can't remember which path they took, but in any case, they spent a couple $1,000s on filing fees, plus the attorney fees, and this is like 8 months ago. There is an infographic later about the process. Right now it's taking about 8 to 9 months between when you apply and when it gets assigned to an examining attorney at USPTO. So they're like, $3,000, $3,500 in the hole on this mark. And sure enough, and I do have in writing, like, I really don't recommend applying without doing a comprehensive search, and they say, no. And they're also like trying to bargain on the fees, which is a red flag, like, you should never. Anyway, sure enough, they got an office action, initially refusing the registration because of a prior mark that's very similar. It's a different spelling, but phonetically it's very similar. They didn't know about it because it doesn't show up as an exact hit. They're very upset, and they had to pay even more money to prepare a response to an office action. So that's just one of many such horror stories, although unique in that we didn't do the search for them. Almost all the time, we do a search before we file the application. Yes.
What I would say is, if you're brainstorming ideas, knockout searches are great.
Yeah.
For you to figure out if that's even an option. But then still having the lawyer in the end do the full search.
Yeah,
but
it's
if
a great
you're brainstorming
first
like
step.
10 different ideas, I would run knockout searches just to say, yeah, that one is already registered. You're not doing it.
Yeah, it's a good first step, but you definitely need to dig down to the deeper layer.
I mean, how's that visit though, really?
What's that?
Do you think Google Elves work there?
Do Google what?
The the United States Patent Office.
What about it?
Like, do you think it's really safe?
Is it safe?
Your concept, your trademark, to just search the.
Yeah.
What do you mean safe?
Search the name
Yeah.
in the database, yeah.
What's the concern? What's the safety concern?
Well, because, you know, if you go to Google and you type in something that wasn't, that's available, and then all of a sudden you do it again, like 5 minutes later, and all of a sudden it's gone, it's not available.
Yeah, the PTO is a defined search, it's not the internet, it's a filing system of all the files that have been filed with the PTO.
Yeah,
So
so.
you think it's pretty safe?
Uh,
Just a bigger idea.
Yeah, I've never heard of someone doing a USPTO search and then within like 5 minutes, another application being filed for that mark. I have had situations where we'll do the search for the client and then for whatever reason, they drag their feet for a couple weeks or a couple months or more. And we always do a confirmatory search right before we file too. And in that couple, 2, 3, 4, 6 weeks, someone else has filed something so similar that I'm like, we need to start over again. So, but I think it would be unusual. I don't think the USPTO is like capturing the search terms or anything like that. I don't know. That's a good question.
I think I know where she's coming from, in her question here, like, so when you search like I'm more or less talking to you, I think when you search a website to see if it's available, for instance, the initial one to see, hey, is this available? I think that's where she's coming from, where some other person will,
Yeah, so especially GoDaddy.
Or a
You search for a
and then all of a
domain.
sudden it's gone when you get your credit card out, it's
Yeah.
gone.
Yeah.
It's
I
not
think
available
that's kind
anymore.
of what she's thinking about, and to
Uh-huh.
answer your question, I don't think anyone's gonna spend $3,500 right off the bat for somebody doing 2 searches on something.
Yeah.
That's a lot of money to sink in on,
Yeah, well also,
on the
I don't
trademark
know
side.
if there is a way, probably, but I don't know if there is a way to access like the entire search history on the USPTO website.
Yeah. It would have to be, if anything, internal, and I doubt that,
Mhm.
knowing, if you've ever gone on tests, it's not exactly the most sophisticated software in the first place, it's the government.
Yeah.
So,
Just so to
the
answer your
lack of
question,
tracking
it's-
is
It's safe.
most likely.
Yeah.
You can do an
I think
initial
it's pretty
search
safe.
on Google,
Yeah.
just not for a website.
I've
Just
searched,
one
let's put it this way,
web.
I've probably run 1,000 searches on there, and
Yeah.
I've never had any
Yes.
disappearance.
Something that has come up with some of my clients, and by the way, just for context,
Yeah.
I work as a brand strategist. So something that's come up with some of my clients, let's just say, just consider this. It's like a local organization and they're kind of starting a new program, and it's gonna be a branded program that's gonna have a lot of public facing interaction with a very specific name. And so kind of just doing an initial clearance search, which is different than your search, is kind of comes before it. It's kind of like
Mhm.
who's using this
Yeah.
name and what are the industries where it's being used.
Mhm.
And so then, in this case, it was for like, they wanted to brand a very specific program for youth and young adults who had aged out of foster care.
Mhm.
There's lots of programs and different things to help them achieve independence and self-sufficiency, but ultimately the name that they initially wanted, it's like it wasn't trademarked and it wasn't copyrighted, but there were a handful of other organizations in Colorado that were using a name that was similar enough that I encouraged them to not use that and to move away from it, just to avoid confusion associated with brand name.
Yeah.
And then they picked another one, and it turned out that there was an organization that was using it, and they had not trademarked it or copyrighted it, but it was actually in Michigan. And again, I just went, how about if you just make your life easier for like, just like, it's a kind of like an insurance policy against the future. Like, let's just pick a different name.
That's smart.
And I mean, I guess I'm just thinking, like, do you have any thoughts or reflections on that? It's like,
Yeah,
it's not a legal thing, but
I think it's a great idea that if the initial search shows that there's someone in a similar industry using a similar mark to scrap it, because you just never know when you're gonna get a cease and desist letter, and again, the more unique your trademark is, the less likely it is that it's going to infringe on anyone else's, and the more likely it is that it'll become a valuable asset of your organization or business. So the last strategy or secret to keep in mind is just to avoid common mistakes. The USPTO will not register marks that are merely descriptive, again, like the gray chair example. Generally, they will not register something that uses a geographic term. However, there are exceptions and you can argue against it. I did get a registration for my client Morrison Outdoors. They actually named their child after the city, even though they're also based in the city. But usually you can't get a registration for something that's geographically descriptive, what else, or generic, or of course the same or similar to someone else's, or by the way, you're talking about US property, you can never get a registration using the US flag or any state flag.